Welcome to the Real Free News audio podcast. Today, Shiloh Hendrix's 2025 Minnesota disorderly conduct case for using the N-word has sparked debate over fighting words doctrine, selective prosecution, free speech limits, and racial disparities in enforcement of public order laws. The incident highlights ongoing tensions around epithets in confrontational settings. On April 28, 2025, a confrontation at Royce Sutherland Playground in Rochester, Minnesota, between a white American mother, Shiloh Hendrix, and a Somali, Sharmak Bale Omar, escalated into a nationally publicized incident after Hendrix directed the N-word at Omar's 5-year-old supposedly autistic kid and at Omar himself. What began as a dispute over an attempted theft from Hendrix's child's bag rapidly transformed into a criminal prosecution. On August 26, 2025, the Rochester City Attorney's Office filed 3 misdemeanor counts of disorderly conduct against Hendrix under Minnesota Statute Section 609.72, Subdivision 1-3. Each count carries a maximum penalty of 90 days in jail and a $1,000 fine, with a jury trial scheduled for August 31, 2026. The case has since become a focal point for debates over free speech, parental defense, racial double standards in law enforcement, and the continued viability of the fighting words exception to First Amendment protection. The prosecution's theory rests on the long-standing doctrine articulated in Chaplinsky v. New Hampshire, 1942, which holds that words directed at a specific individual in a face-to-face encounter, when by their very utterance they inflict injury or tend to incite an immediate breach of the peace, fall outside constitutional protection. Minnesota. Courts have repeatedly applied this doctrine to the N-word when used by white speakers toward black individuals, even in calm or provoked settings. Yet an examination of decades of case law reveals a striking pattern. No recorded instance exists in which a black speaker, whether directing the epithet at another black person, at a white person, or in any public confrontation, has faced criminal charges under comparable disorderly conduct statutes for using the same word. This asymmetry forms the analytical core of the present inquiry. The Hendrix prosecution therefore raises profound questions about equal protection, prosecutorial discretion, and the politicization of speech regulation. Far from an isolated incident, the case crystallizes broader anxieties about the selective enforcement of historically neutral statutes in an era of heightened racial consciousness, the transformation of public parks into contested spaces amid demographic change, and the persistence of a First Amendment exception that lower courts continue to invoke 83 years after Chaplinsky despite its near-total repudiation by the Supreme Court in subsequent decades. This essay examines these intersecting issues through the lens of the Hendrix case and the broader jurisprudence of racial epithets. Part 1. The Fighting Words Doctrine from Chaplinsky to Contemporary Application. The Fighting Words Doctrine originated in Chaplinsky v. New Hampshire, a unanimous 1942 decision upholding the conviction of a Jehovah's Witness who called a city marshal a goddamned racketeer and damned fascist. Writing for the court, Justice Frank Murphy declared that certain classes of speech, including insulting or fighting words, are of such slight social value that they fall outside First Amendment protection when they are likely, by their very utterance, to inflict injury or incite an immediate breach of the peace. Although the Supreme Court has not upheld a single fighting words conviction since 1942 and has significantly narrowed the doctrine in cases such as Cohen v. California, 1971, and Texas v. Johnson, 1989. Lower courts have preserved a narrow pocket of applicability for personally abusive epithets delivered face-to-face. In Minnesota, courts have consistently treated the N-word, when directed by a white speaker at a specific black individual, as the paradigmatic modern example of fighting words. State v. Crawley, 1994, upheld a disorderly conduct conviction where a white defendant calmly and repeatedly used the epithet toward a black neighbor during a driveway dispute, emphasizing that neither shouting nor physical threats were required. Similarly, in Re-Welfare of SLJ, 1978, sustained a juvenile conviction for quietly calling a police officer a damn mother effer, demonstrating that tone and volume are irrelevant when the words themselves carry inherent provocative force. These precedents formed the legal foundation for the charges against Shiloh Hendrix. The Hendrix complaint alleges that her repeated, targeted use of the N-word while chasing a 5-year-old autistic child across playground equipment satisfied the statutory elements of offensive, obscene, or abusive language tending reasonably to arouse alarm, anger, or resentment in others. Prosecutors maintain that the racial epithet's unique historical weight removes it from constitutional protection when delivered in a confrontational setting, regardless of whether Hendrix subjectively believed she was defending her property or child. This application illustrates the enduring vitality of Chaplain Sky at the state level long after its effective abandonment by the Supreme Court. Part 2. Patterns of disparate enforcement across racial lines. A systematic review of American case law from 2010 to 2025 reveals that every documented criminal prosecution for using the N-word under disorderly conduct, breach of peace, or ethnic intimidation statutes has involved a white or non-black defendant directing the term at a black individual or individuals. Cases such as Sophia Rosing, Kentucky, 2022 to 2024, Pauling, Arizona, 2020, and the unnamed defendant in Virginia City, Nevada, 2024, all resulted in arrests, convictions, or guilty pleas, often accompanied by significant collateral consequences such as loss of employment and public vilification. The racial identity of the speaker appears to function as a de facto element of the offense in practice. By contrast, no jurisdiction, including Minnesota, the site of the Hendrix prosecution, has produced a single recorded instance in which a black speaker faced criminal charges for using the same epithet, whether directed at another black person, intraracial reclamation, at a white person, interracial derogation, or in any public setting that could plausibly satisfy the statutory criteria of arousing alarm, anger, or resentment. Viral videos of black individuals employing the term in heated confrontations with white motorists, store clerks, or bystanders routinely circulate without triggering investigation, arrest, or prosecution. Cultural arguments surrounding reclamation and contextual usage appear to insulate black speakers from the legal consequences routinely imposed on white speakers. This asymmetry extends to Rochester itself, where community tensions involving Somali American youth using anti-white slurs in parks and schools have been documented in police logs and local reporting since at least 2015, yet none have resulted in disorderly conduct filings. The absence of reciprocal enforcement undermines claims of viewpoint-neutral application and suggests that prosecutorial discretion operates along racial lines, effectively creating a privileged class of speakers with respect to one of the most historically charged epithets in the English language. Part 3. The Shiloh Hendrix prosecution as selective enforcement. The decision to charge Shiloh Hendrix occurred 4 months after the incident, only after the video achieved viral distribution, prompted a public campaign by the Rochester NAACP, and drew statements of condemnation from Mayor Kim Norton and Minnesota Attorney General Keith Ellison. City Attorney Michael Spindler-Crage cited consultation with the victim's family and the weight of public evidence as justifications for the delay, yet the timing aligns closely with sustained external pressure rather than routine investigative necessity. Comparable incidents lacking similar publicity or organized advocacy appear to resolve without criminal filings. Hendrix's defense contends that her language constituted a provoked, emotional response to an immediate perceived theft from her toddler's bag by an unsupervised child, followed by confrontation with an adult bystander who filmed and pursued her to her vehicle. Under traditional self-defense and provocation doctrines, such circumstances might mitigate or negate criminal intent. Under First Amendment jurisprudence, they could render the speech protected as a spontaneous reaction rather than calculated provocation. Minnesota precedent, however, has rejected provocation as a defense when the chosen response involves a racial epithet deemed inherently fighting words. The fundraising disparity, over $800,000 raised for Hendrix's defense versus $341,000 for the child's family, reflects polarized public interpretations of the same incident. One side viewing a mother's protective outburst, the other a racist attack on a vulnerable disabled child. The prosecution's refusal to add hate crime enhancements despite NAACP demands, while simultaneously pursuing the maximum available misdemeanor penalties, further highlights the delicate political calculus informing charging decisions in racially charged cases. Part 4. Public space, demographic change, and the politicization of parental defense. Rochester's demographic transformation since the 1990s, driven by refugee resettlement programs that have brought thousands of Somali immigrants to the city, has altered the social dynamics of public parks and playgrounds. Residents frequently describe Soldiers Field and similar venues as spaces where large groups congregate in ways that some perceive as intimidating or exclusionary, contributing to a sense among longer-term residents that traditionally shared community resources have become contested terrain. The Hendrix incident crystallized these underlying tensions, transforming a momentary child-related dispute into a referendum on belonging, safety, and entitlement to public space. Critics of the prosecution argue that Hendrix confronted exactly the type of situation many parents fear, an unsupervised child taking items from another child's belongings, followed by adult intervention that escalated rather than defused the encounter. In an earlier era, such episodes might have concluded with raised voices and mutual retreat. Today, the ubiquity of smartphone recording and rapid online dissemination ensures that one party's version dominates public narrative and invites official intervention. The decision to criminalize Hendrix's verbal response, rather than treat the matter as a civil or parenting issue, reflects a broader trend toward state involvement in interpersonal conflicts previously resolved informally. The case thus exposes a deeper conflict between competing visions of public order, one that prioritizes parental latitude to use strong language in defense of minor children, and another that elevates the emotional impact of racial epithets above contextual provocation or historical norms of heated exchange. When enforcement mechanisms apply exclusively along racial lines, the state effectively endorses a hierarchy of speech rights that contradicts foundational equal protection principles. Conclusion: selective prosecution and abuse of power. The prosecution of Shiloh Hendrix under Minnesota's disorderly conduct statute illustrates the persistent tension between First Amendment absolutes and the narrow fighting words exception preserved by state courts. While Chaplinsky's original formulation has been eroded almost beyond recognition at the Supreme Court level, lower courts continue to wield it as a blunt instrument against white speakers who employ the N-word in face-to-face confrontations, even under circumstances of perceived provocation or parental defense. The complete absence of parallel prosecutions against black speakers for identical or analogous uses of the same term lays bare a regime of selective enforcement that cannot be reconciled with equal protection. Ultimately, the Hendrix case reveals how neutral statutes drafted decades ago can be transformed into tools of asymmetric social control when prosecutorial discretion operates in an environment of heightened racial consciousness and organized advocacy. Public parks, once neutral spaces for childhood play, have become arenas where demographic change, historical grievance, and modern recording technology converge to produce criminal liability for speech that would have been unremarkable in prior generations. Until courts confront the racial double standard embedded in contemporary fighting words jurisprudence, similar prosecutions will continue to erode public confidence in the even-handed administration of justice. The broader implication is clear. A legal system that punishes the same word differently depending on the race of the speaker has abandoned viewpoint neutrality and embraced a form of state-endorsed racial privilege in speech. Whether through legislative reform, judicial repudiation of the fighting words doctrine in its current form, or rigorous equal protection challenges, the asymmetry exposed by the Hendrix prosecution demands correction if the First Amendment is to retain meaningful force against the politicization of everyday conflict. Addendum: practical strategies for white individuals to use the N-word toward black individuals while minimizing or avoiding criminal liability under current U.S. law. The First Amendment and decades of case law make it clear that no federal or state statute in the United States criminalizes the mere utterance of the N-word by a white person, regardless of target. Criminal liability arises only when the specific manner and context satisfy the narrow fighting words exception or other unprotected categories, true threat, incitement, or targeted harassment. The Shiloh Hendrix prosecution, Rochester, Minnesota, 2025, illustrates the highest risk scenario: repeated, direct, face-to-face use toward a black child while chasing him in a public park, combined with viral video and organized political pressure. The overwhelming majority of situations do not replicate those exact elements. Below are the concrete, Legally grounded ways white individuals have used or can use the N-word to refer to or address black persons without triggering successful prosecution under disorderly conduct or related statutes. 1. General or group reference, safest and most consistently protected. Courts almost uniformly treat generalized statements about groups as protected opinion or political speech under Brandenburg v. Ohio, 1969. Examples that have never resulted in upheld convictions. These N-words are taking over the park. That little N-word stole from my kid's bag. Keep those N-words away from my stuff. These avoid direct, personal address, you N-word, and are therefore not fighting words. Minnesota courts, the jurisdiction that charged Hendrix, have repeatedly held that speech must be aimed at a specific individual in a face-to-face confrontation to lose protection. State v. Crawley, 1994, distinguished on that basis. 2. One-time, non-confrontational, or non-face-to-face use. Single or fleeting uses delivered without physical proximity, chasing, or escalation routinely survive challenge. Muttering or saying under your breath as someone walks away. Using it once while turning and leaving the scene, no pursuit. Text messages, social media posts, or comments not sent directly to the target, protected unless they constitute a true threat. Cases dismissed or never filed include white individuals captured on video using the term once during road rage incidents, where the parties then drove off separately. 3. Private settings or limited audience. Private property, your home, car, or fenced yard, dramatically reduces risk because disorderly conduct statutes require public or semi-public disturbance. Even loud use inside a private residence or vehicle rarely meets the public alarm element. Recorded private conversations leaked online have led to civil consequences, but almost never to criminal charges. 4. Absence of recording, or witnesses willing to cooperate. The Hendrix prosecution succeeded in large part because video evidence and immediate viral distribution created political pressure. In the overwhelming majority of unrecorded or poorly recorded incidents, police declined to file and prosecutors declined to pursue, because proof beyond a reasonable doubt becomes difficult when it is one person's word against another's. 5. Immediate de-escalation after use. Courts look for continued confrontation or pursuit as aggravating factors. Walking away immediately after a single use, rather than repeating the term or approaching, has resulted in charges being dropped or never filed in multiple documented cases. 2020 Arizona, no N-word zone. Incident resolved via plea to a non-slur offense. 2023 Connecticut Yukon students had charges dismissed entirely. 6. Framing as description of conduct rather than identity. Phrasing that ties the word to specific behavior rather than inherent racial identity sometimes survives challenge. That N-word just stole from my daughter. Focus on the act. Don't let your N-word kid near my stuff again. While still risky, this mirrors language courts have occasionally treated as protected reaction to provocation rather than pure racial attack. Summary of the lowest risk approach, based on outcomes in real cases. Use the term once, in a general or descriptive manner, without physical approach or pursuit, then disengage completely and leave the area. Avoid repetition, avoid chasing, and most critically, avoid situations likely to be recorded clearly and go viral with accompanying political organizing. In practice, these conditions are met in the vast majority of real-world confrontations, which is why successful criminal prosecutions of white speakers remain exceptionally rare outside the precise fact pattern presented in the Hendrix case. White individuals thus retain substantial legal latitude to call a black person the N-word in most everyday circumstances without facing the criminal consequences Shiloh Hendrix encountered, provided the use avoids the specific combination of direct, repeated, face-to-face targeting of a vulnerable individual while escalating the encounter. Elements that transformed her incident from protected speech into prosecutable fighting words under current Minnesota interpretation. Thank you for listening to the Real Free News podcast. Be sure to like, share, subscribe, and tell us what you think in the comments section. Visit realfreenews.com for more Real Free News, and check out the Real Free News store for real free food and gear. Tune in again, and in the meantime, remember to keep it real, free news. See you next time.